Hey folks, James Abrinio coming to you from Abrinio Law. This video, let's talk about personal injury settlements. You've probably seen them everywhere. Personal injury attorneys bragging about huge $1 million settlements, hundreds of thousands of dollars settlements. But you're probably asking yourself, well, what does that actually mean for the client? How much does the client actually get at the end of the day? Before I started practicing personal injury law, I would see the judgments and I would also have the same question. I figured I was going to use this video to help just clarify a few things. So what I'm bringing up to the screen right now is an internal document, an internal settlement statement that my firm actually uses when we are resolving cases that have either reached a settlement, a financial settlement, or we've went to trial and earned a judgment. And typically speaking, when we're handling personal injury cases, we are getting money from insurers. So if you're insured by Geico and we get a $500,000 judgment against you, and let's say you've got $1 million in coverage, Geico is cutting that check for $500,000. So to help clarify, I've created, again, this is a settlement statement that we use. And to be clear, I have used a hypothetical client, John Doe, address hypothetically 111 Made Up Street, Fairfax, Virginia. And again, just for hypothetical, I just pretended that the insurance company here is Progressive, and I am just pretending that we ended up resolving the case for $500,000. And just to be clear, by resolving, it could have been by a settlement, an actual settlement agreement where we've negotiated with the insurance company, you, the client, in this hypothetical, have given me authority and we settled it and resolved it. Or we couldn't reach an agreement with the insurance company, so we ended up going to trial. And let's say, again, a jury gives us an award of $500,000. So what happens next is I actually get a settlement check addressed to my law firm in this hypothetical, as well as the client, which would be you here, John Doe. And then I would submit it, deposit it into my into my firm's what we call a trust account. So essentially, this is an account monitored by the Virginia State Bar. It is not my money until I've earned it. And so you have $500,000 sitting in this account. So obviously, money going to the trust account is not solely for the attorney. It is to be accounted for and then dispersed accordingly. And this sheet, this disbursement sheet, this settlement sheet is really helping explain where we go from there. And again, you're seeing I'm bragging about a $500,000 judgment. This is what happens on the back end. So as we look here, it's kind of straightforward. Again, I'm using hypothetical providers, health insurance liens, and I'll just walk you through this. So in my scenario, I essentially say Progressive sent us over $500,000. Total receipts collected, $500,000. You may have certain cases where, let's say there's two different insurance companies involved because there's a liability carrier and an underinsured motorist carrier. And that's not the subject of this video, but let's say you get checks from two different insurers. Here, we would just add it up. So let's say you get 250 from liability and 250 from UIM. Now you're looking at 500. So just for hypothetical, that keeps it pretty straightforward. All right. So the next step we're looking at is, again, this is pretty logical, the disbursements. Okay. And what disbursements mean is what is going out the door. And down here, you'll see remaining proceeds. That means what's going to the client. So here, John Doe. So disbursements, whenever you're looking at judgments, you're looking, and this is going to be called a contingency fee. Most firms operate on what we call a contingency fee. What that means is you pay the attorney a percentage of what you get on the back end. You don't pay them a flat fee up front. You don't pay them an hourly fee. The attorney charges you a contingency fee. And in this hypothetical, we've charged an attorney's fee of 25%. So just using that. Now, just to be clear, that contingency fee amount can change. Different firms use different contingency fee amounts, some higher, some lower. Some contingency fee amounts will scale depending on when the case resolved. So for instance, in our firm, a lot of times I'll set for just a standard car crash case, I will have an agreement that my contingency fee is 25% until we get within 3 months of trial, within 90 days of trial, and then it goes up to a third. And then it'll go higher if we have to appeal it and things like that. But the reason we do it that way is we figure if we can settle a case sooner rather than later with less work, the client should get the benefit. But for, again, purposes of this discussion, I'm just giving you the math so you can see it. So let's assume here the attorney's fees is 25%. So it's really pretty straightforward. And I'm literally got out my calculator right now. I'm pulling it up. So we're saying $500,000 times 0.25, which is 25%. So that is $125,000. So that is $125,000 is coming from this $500,000 amount. The next thing is we're looking at what we call cost reimbursements. And again, this is hypothetical. This will vary depending on the case, depending on where the case resolved or if it had to go to trial. Costs involved for reimbursement are things oftentimes the attorneys' firms, the law firms will prepay and then get paid on the back end. So we do that at our firm. So things like filing fees, costs to get medical records and medical bills. If we're doing depositions, a big cost is expert testimony. So let's say we've got to hire a neurologist to testify that your brain injury was actually due to the crash and not like the defendant's neurologist is saying either you're making it up or it has nothing to do with the crash or it's pre-existing condition. These cost reimbursements can get pretty high. I'm estimating a relatively low one here. I mean, if we're litigating a brain injury full the way to trial, this could easily reach $50,000, $75,000, $100,000. So just be aware of that when you're looking at what resolution is good for you, should you settle or not. But I've just lumped that in our settlement statement for cost reimbursement here, hypothetical $15,000. And by the way, when I do this and I give the client this on the back end, when we're ended up giving them the disbursement, I'm actually breaking down this cost reimbursement details so they see exactly what is coming out of that. So that's that. Now, the next thing we're moving on to is outstanding bills. And what do I mean by outstanding bills? Outstanding bills are you got medical treatment, health insurance paid a good amount, but you got bills that you still owe. Either your deductible is high or for whatever reason it wasn't covered. Maybe it was out of network care. Again, in this, this hypothetical, I'm just using these examples. So I'm just throwing up some numbers there. Nova Fairfax, we're saying it's $3,500 owed. Maybe that's the ER bill and it didn't cover a CT scan. Maybe you were in the hospital and that was just amount not covered by your deductible. Again, hypothetical. And then I'm just throwing Kaiser primary care. Maybe you went to your primary care doctor several times for some x-rays and just general follow-up visits and it's still outstanding. And those will be paid outside from the settlement funds. Typically, they will be paid from your settlement funds unless you've arranged with your attorney another agreement. Typically, at least here in our cases, I will be letting the client know and the client will be letting me know that there's still outstanding bills and we'll pay that from the settlement. Okay, the next thing, and this is something that surprises a lot of people, is health insurance liens. What is a health insurance lien? Here I've got Aetna, $35,000. What is a health insurance lien? That's a pretty important thing to be aware of. If you have health insurance and they pay your bills, depending on the health insurance contract, they may have a right to reimbursement. The benefit of that, though, is they only have the right for what they paid out, and typically health insurers will get a negotiated rate down. So let's say in this hypothetical, you have a health insurance lien of $35,000. That will mean that the bills were somewhere higher than that because they presumably got a negotiated rate. So in this scenario, again, for hypothetical discussions, let's say your bills were $70,000, your health insurer ended up only paying $35,000. So when you're claiming and you're settling for this $500,000, you're getting that money based upon medical bills of $75,000 in this hypothetical, when on the back end, you only have to reimburse the health insurance for $35,000. So the math actually in a lot of ways makes a lot more sense. I know it's upsetting to a lot of people if health insurance end up asking for reimbursement. It's like, well, I paid my premiums and now you're asking for money back. That's just the way it goes. To be clear, not every health insurer has a right to reimbursement. Other health insurers will absolutely have a right to reimbursement. So we're talking about government-sponsored plans. So we're talking about federal health insurance policies. We're talking about Medicare. We're talking about Medicaid, TRICARE. Now, also, if you have certain health insurance policies, specifically Medicaid, Medicare, there are other things that you need to be considering when you're settling your cases. For instance, and I'm raising this issue. This is not attorney advice, it's an informational purpose only. But let's say for Medicaid, a lot of times you're getting Medicaid on an income sensitive, need-based eligibility. So if you get personal injury settlement, not only you have to reimburse Medicaid, you may end up getting your Medicaid benefits cut. Medicare, you're not going to get your Medicare typically because you're qualifying for by age. You're typically not having your Medicare benefits cut off, but you may have an obligation for future reimbursement if, let's say, you have a permanent injury and you're going to have to get future care under the Medicare program. So those are things that you absolutely need to talk to your attorney about that are detailed, specific to the facts of your case, specific to the facts of your plan, specific to the facts of the state that you're in, and all that. Now, I want to be clear. My firm practices in Virginia. Again, this is informational only. And so when I'm talking about this case and settlements in general, it's kind of geared towards Virginia. But this video, again, is not meant to give you exact advice. It's really just to help you wrap your head around what you should be looking at and looking for if you end up hiring an attorney for your own case. So now we have kind of the 1,000-foot view of what are the numbers coming from your case. And then the question now is what is the client going to get? So I'm going to do the math here. Now we've got our fancy little calculator. Okay. So we're going to walk through that hypothetical again. I'm going to clear this. Settlement $500,000. And then we're going to say times 0.75 because that's taking away the attorney's fees, $125,000. And then we're going to say minus 15,000. That's for the cost reimbursement, doctor's expenses, filing fees, depositions, all that. Now we're talking about $3,500 that goes to, and again, this hypothetical, Inova Fairfax. Boom. And then we're going to take away the $1,500 owed to Kaiser. Boom. And then we're going to take away the $35,000 owed to Aetna. So now we're looking at $320,000 in this hypothetical that would go to the client based upon a settlement of $500,000. Boom. So we did the math. So again, $500,000, take away the $125,000, take away the $15,000, take away the $3,500, take away the $1,500, take away the $35,000, and now we're looking at $320,000. What the client should expect in their pocket. So hopefully this helps you understand how that will work if you hire an attorney. And again, generally the ideas of what you should be looking for. Obviously, if the attorney's fees is higher, it's going to change this hypothetical. If the cost reimbursement is higher, it's going to change this hypothetical. If the lien is higher, it's going to change this reimbursement number. And of course, every number that is going to disbursements under the way we do it, that's coming from the plaintiff's proceeds. And, look, a couple things to be thinking about. Number one, when you're talking about settlement values with your attorney, they're going to say something like, look, in this case, Progressive is offering $500,000. Do you want to go ahead and settle? You want to make sure that you have a good idea of the net value that's actually going to go into your pocket. A lot of times, myself included, when we're talking about these numbers at this stage, let's say $500,000 has been offered, and let's say we've got trial in a month or in a week or whatever. A lot of times I won't be able to give you the exact number of what you should expect in your pocket because there's still some outstanding bills and still things on the back end that need to be charged. But I can usually give you a general idea of what you should expect. There's a few caveats. For instance, let's say there's a huge health insurance lien that maybe it's Medicaid and they're taking forever to respond, so I don't have the numbers. Maybe I'm trying to get a health insurance lien reduced, and that may or may not happen. But you should still have a decent framework, a good idea of what you should expect when you settle. Look, if you don't have an idea, then you got two choices. You can just go to trial and it is what it is, or you can just take the settlement based upon, the best information you have. But again, usually you should have your attorney should be able to give you a decent sense of what you should be able to expect in your pocket. A couple other things. For instance, like I said, in my firm, we have a sliding scale attorney's fees, contingency fees. So it'll go from 25% to a third, sometimes higher, depending on if the case gets appealed, stuff like that. You want to be considering that sliding scale if that applies in your case, because if the attorney's fees goes higher based on a certain deadline or a certain activity, and you can settle it even if it's less money, but you end up with more money in your pocket, then you need to think about that. Same thing with the cost reimbursement. Let's say you're going to have to pay a doctor an extra 20 grand to come to trial, and the attorney's fees may go up. And now let's say you get offered 500, but you think it's worth $600,000 at trial. But when you do the math and considering an increased attorney's fee, increased litigation costs, you're actually still come home with $325,000 or whatever it is. And then hypothetical, it may be my advice to you that it's a safer bet to go ahead and settle versus try the case. Next thing to think about that, though, and I want to be clear, and I tell clients this all the time, ultimately it is not my decision about whether or not you settle your case. And it is not any attorney's decision about whether you settle your case. The client gets that choice. The attorney cannot force you to settle a case, okay? So just keep that in mind. And so hopefully this helps you understand when you see these $1 million verdicts, you see these multi-million-dollar verdicts, you see these hundreds of $1,000 verdicts. Look, I'm not discounting that those verdicts great. Look, we advertise them as well. We love them. We, of course, want the biggest number because we think that it reflects the hard work we put in. We also think it reflects, obviously, the severe injuries, catastrophic injuries that somebody has been forced to go through. And so it matters. Even, of course, we or the defense attorney or the insurance company, the defendant can't take away your pain, but at least you can be validated in seeing a big number. But more important that the number that the attorney is advertising is the number that you're going to get in your pocket. So you need to be clear with your attorney, and the attorney needs to be clear with you about what you should be able to expect, because that should matter to you more than the actual settlement amount. So hopefully this helps out. Wish you guys the best. Feel free to reach out if you got questions. Of course, if you got a case here in Virginia, reach out. We'll try to help you out. Wish you guys the best.